Я бы все-таки хотела, Марина, я хотела бы, чтобы все сюда пришли, потому что разговор будет о деталях, чтобы все слышали. Так, я хочу открыть эту очень важную для семинара и для школы сессию, потому что сегодня мы будем говорить о том уникальном, универсальном и одном из самых важных институтов современного демократического государства, который называется независимый суд. Независимый суд – это как бы слово...
Independent judiciary, that is a word combination that is understood only together. However, in real life, with all my respect to judiciary and their professionalism, it's an often case when the word independent is dropped off at some point. And so it so happens that it's the issue of not only for the profession, but for the culture as a whole. You cannot lose independence, otherwise we will lose the meaningness of the institution itself. So today we're going to dedicate the session exactly to that issue. So I'm going to be quite brief, and I would like to be very grateful to our next lecturer who came to this session specifically, and she's a judge of that famous court in the world, which is called the Court of the United Kingdom. I would like to say a couple of words for your clarification, since while we are talking about independent judiciary, I would like you to turn your attention to cultural aspects and to nuances which result in the idea of the independent judiciary. And to introduce Marcia Levy as a judge of England, I was supposed to say that, and in Russian, I can really introduce her only as Your Highness or Your Honor, but I think Marcia would explain to you that such an attitude is very important for independence, since it's really about honor as a position. So that's a word game becomes quite unique, since when your effort is nearing completion, you should appeal to the symbol of justice and independence, that you have performed the service, you have delivered the service, not only for the defendant and for the plaintiff, but you have also contributed something to the abstract notion of justice. And so her lecture will be very important for us, and I would like to spend another minute to explain to you that Marcia is very close and long-time friend for Yuri and me. Together we were the founder of the school. She believed in that school, and I think she continues to believe in that. She came here as an expert. Now she's come again, and Marcia, 20 years ago the school was set up, and every year, or throughout this year, we celebrate its 20th anniversary. And there are only a few experts who were with us at the foundation of the school were awarded a picture by an artist who first made our logo, but then actually it's not a picture, it's not a painting, but that's a dish and to commemorate the 20 years during which we stayed together. Certainly I could present here with that plate in private, but you can see how beautiful that plate is. And it's handmade. It has our logo. So, Marcia, it's yours.
Good afternoon, ladies and gentlemen. It is a great pleasure and indeed a great honor for me to be here again at the Moscow School for Civic Education seminar in Golitsyno. It's not my first visit. I've been here 2 or 3 times before. I maintain the link. I think it's extremely important. The work that Lena and her colleagues and all of you do in coming to these seminars is extremely important. Before I start my talk, I want to make it clear that most of what I have to say is by way of providing you with information. Information about the way in which English judges are appointed, how their independence is set out in law, how it is supported in many ways. If I express an opinion, then the opinion is my own. I'm not speaking on behalf of the English judiciary. Well, I have been a lawyer for a very long time, 37 years. And for the last 10 years, I have been a circuit judge. It's difficult to translate circuit judge into Russian or any other language. And it's quite difficult to explain it in English because some of the names that we have for different aspects of our system are very old, are historical, and nobody quite knows why things are still called the way they are. So perhaps the best way to describe myself is a mid-level judge in the administration of justice in England and Wales. Before I became a judge, I was a practicing lawyer. And over the years, I gained experience in many different areas of law, including commercial law in London, and including 5 years as a commercial lawyer in Moscow in the 1990s. Now, as a judge, my main area of expertise is family law, in particular cases involving children, but I also hear civil cases, and I sit with a jury as a judge in the criminal courts. So I am a practitioner. I'm not an academic lawyer. I'm not a philosopher. Every working day, I make decisions, many of them difficult, some painful, and all of them on my own. This can be a very lonely job. I have total responsibility for my decisions, whether to remove a child from his birth family, whether to deprive a person of his home, or to send an offender to prison for many years. But the question I want to consider with you this afternoon is, am I acting independently when I decide another person's fate? English judges are appointed by the Queen, and every judge is sworn into office by taking an oath that he will well and truly serve Queen Elizabeth II in the office of, in my case, circuit judge, and do right to all manner of people after the laws and customs of the country, without fear or favour, affection or ill will. That oath asserts, right at the beginning of a judicial career, that a judge's decisions will be made under the rule of law and that the judge will act independently. I know that this session today is generally under the title of the rule of law, and forgive me if I repeat some of what you have already heard. But I think it's important for me to put the work that I do and the way in which English judges work into context. The rule of law was defined by the late Lord Bingham, a law lord, a senior judge who visited Moscow when I was here, in a book that he wrote called The Rule of Law. And he defined it in this way: the core of the principle is that all persons and authorities within the state, whether public or private, should be bound by and entitled to the benefit of laws publicly made and publicly administered in the courts. The principles of judicial independence and their implementation have been formulated many times. One example to which I will refer is the Latimer House Guidelines on the relationship between the three branches of state, which were agreed by the Commonwealth heads of state in 2003. These guidelines identify certain fundamental values in this way. We believe in the liberty of the individual under the law, in equal rights for all citizens, regardless of gender, race, colour, creed, or political belief, and in the individual's inalienable right to participate by means of free and democratic processes in framing the society in which he or she lives. These values place the rule of law at the heart of a democratic society. But if the rule of law is to be upheld, the judges must be independent. Individual judges and the judiciary as a whole must be impartial and independent of all external pressures and of each other, so that the people and the corporations who appear before them and the wider public can be confident that their cases will be decided fairly on the basis of the relevant facts as presented by evidence in court and in accordance with the law. Going back to the words of the judicial oath, the words "without fear or favour, affection or ill will" assert the judge's independence. The idea, the concept of judicial independence first appeared in English law about 300 years ago. And that was in a law which said that senior judges would continue their work while they were of good behaviour, and that there had to be proper procedures if a judge was going to be removed from his position. Before that, judges could be removed if they did not decide cases in accordance with the wishes of the King or the Queen. Judicial independence is also essential to the separation of the three branches of state: the executive or government, the legislature or parliament, and the judiciary. All of them must function independently from one another. So this raises the question, independent from whom or from what? In this talk, I'm going to consider some of the potential sources of improper influence on a judge. So I'm going to look at the following: independence from the executive, including looking at the way in which judges are appointed and how they're employed, and at the question of judicial immunity, certain protections that judges have when they're carrying out their duties. I will look at independence from other judges and how our system provides consistency between judges who are independent of one another. I will look at independence from Parliament, the relationship between the media and the judges, and the effect of public opinion. And lastly, I'll say a little bit about European law and the effect that that has on English law and English judges. So, first of all, who are the judges? English judges are appointed from the practicing legal profession. They are either barristers, and your nearest equivalent is advocate, or they are solicitors, and there's no real equivalent for a solicitor in the Russian legal system. It's somewhere between an advocate and a notary. We do not have a separate career path which starts after university and trains young lawyers to be judges, as does happen in Russia, in France, in Italy, for example. Practicing lawyers, from whom judges are selected, all have a long tradition of independence as practitioners. And it's a tradition which places a high value on individual judgment. So, for example, barristers, advocates, still apply a rule which is called the cab rank or the taxi rank rule, which means that, like a London taxi, they have to take on the next person who comes along, whatever their assessment of that person or his case. And solicitors, too, act as independent legal advisors, and their advice on the law is not always what their clients want to hear. It is not the function of the judiciary to represent the views and wishes of society. That is the role of the democratically elected legislature. However, it is generally thought that judges should be more representative of society as a whole than they have been traditionally. And this refers to the gender of judges and the social and ethnic makeup of the judiciary. Independence from the executive. The process of ensuring that judges are independent begins with their selection. As I explain the laws and traditions that support judicial independence, I will mention two people, so I should start by explaining their roles within our system. The first is the Lord Chancellor, who is a senior member of the government and a member of the cabinet. He is responsible for the efficient functioning and independence of the courts. The Lord Chancellor is also Secretary of State for Justice. In other systems, he would be called a Minister for Justice. He is a politician, not a lawyer. The Lord Chancellor is obliged by law to uphold the continued independence of the judiciary. The law provides that he and other ministers must not try to influence particular judicial decisions through any special access to the judiciary. The Lord Chancellor must have regard to the need to defend judicial independence and the need for the judiciary to have the support necessary to enable them to exercise their functions. The other person I will mention is the Lord Chief Justice, who is the head of the judiciary and President of the Courts of England and Wales. That suggests, and it is the fact that he is a lawyer and also a judge. Representing the executive and the judiciary, they have joint responsibility for a number of aspects of judicial independence. The appointment process. In England and Wales, as I've explained, judicial appointments are made by the Queen on the advice of the Lord Chancellor. Judges are not elected, and nor is there any provision that legal appointments are scrutinised and confirmed by the legislature although both those systems exist elsewhere, for example, in the United States. The Judicial Appointments Commission is an independent body which conducts the appointment process. Judges are represented on the commission, but they are in the minority, and the chairman is not a lawyer. Application is by open competition, which is advertised in the press. Candidates for appointment as a circuit judge, even those who are already judges at a lower level and are applying for a promotion, have to demonstrate by reference to their experience that they meet a number of criteria. And these include intellectual capacity, knowledge of the law and expertise, the ability to absorb and analyze a great deal of information quickly, a willingness to learn and develop professionally, and I'll come back briefly to the subject of training in a few minutes. The personal qualities that candidates have to demonstrate are integrity, independence of mind, sound judgment, decisiveness, and objectivity. Candidates have to demonstrate an ability to understand and deal fairly with the people who come before the courts. And this includes an awareness of the diversity of society, a commitment to justice, independence, commitment to public service, fair treatment, and a willingness to listen patiently and with courtesy. Candidates for judicial office also have to have authority. They have to have increasingly some level of communication skills, and they have to be efficient because there's a great deal of work to do. The Commission recommends appointments to the Lord Chancellor, and he has very limited powers to veto their suggestions. I looked for the most recent statistics about the makeup of the judiciary. I was able to find some figures for circuit judges, so judges at my level. The most recent figures I could find are at the 1st of April 2012. But at that time, there were 665 circuit judges, of whom 17%, 114, were women, which of course tells you that 83% were men. And 1.7% were from the black and ethnic minorities. So bearing in mind that I said that there's a view that judges should represent the diversity of society, you will see that we have still got quite a long way to go. Terms and conditions of service. The terms of service of a judge must ensure that he's not subject to personal or institutional pressure. A judge must never feel that if he doesn't please the government, his salary will be at risk. Our salaries are fixed by the government, but on the recommendation of an independent senior salaries review body, although sometimes the implementation of those recommendations is delayed, as it has been during the recent financial crisis. Many lawyers who become judges, not me, but many lawyers who become judges, give up much higher incomes which they earn in private practice. The level of the salary is intended to provide reasonable remuneration, not compared with what you might earn if you were in commercial practice, but sufficient to encourage good people to apply for judicial appointment. Judges must not only be independent, they must be seen to be independent, and this requirement places restrictions on a judge's activities outside of judicial office. The general principle is that while holding judicial office, a judge must behave in a manner which is consistent with the authority and the position of a judge. A judge must not engage in any activity which might undermine, or which other people might reasonably think would undermine, their judicial independence or impartiality. So to give you some examples, a judge cannot take on any other paid employment. A judge cannot hold a commercial company directorship, even if it's unpaid. A judge cannot take part in any political activity. A judge cannot stand for Parliament. And when they leave office, they're not allowed to go back into practice as barristers or solicitors. And a judge is expected to conduct his private life in such a way that there will be no conflict and there will be no embarrassment. I said I would say a little bit about training. The Judicial College, which is a virtual college, which has occasional seminars, not unlike the Moscow School, provides training for judges after appointment and throughout their judicial careers. The training covers, of course, law and evidence and procedure, but also increasingly management and leadership skills and the social context within which judging takes place. Attendance at training is mandatory. There is literally no excuse unless you are in hospital. And if you fail to attend, that can become a disciplinary procedure. Training methods include residential seminars, day courses, electronic letters, and distance learning. And it's provided mostly by judges, also by academics and people from related areas of work. So, for example, there might be lectures from prison governors, psychiatrists, psychologists. And the standard of training is very high. And it's important because this high level of training gives judges a sound basis from which to exercise their independent judgment. I mentioned disciplinary proceedings. If judicial independence is to mean anything, judges must know that they have secure tenure and can only be dismissed from office after a set procedure has been followed. However, a judge is not protected from complaint or criticism of his conduct as a judge. The Judicial Conduct and Investigations Office supports the Lord Chancellor and the Lord Chief Justice in their joint responsibility for judicial discipline. The office investigates complaints about the personal conduct of a judge in court. It cannot deal with complaints about judicial decisions. They have to go through the appeals procedure. These complaints against judges and their behaviour in court are taken very seriously, although the number of complaints and the number which are upheld is quite low. Again, some fairly recent figures for the year 2012-2013, so that'll be from the beginning of April to the end of March. The Judicial Conduct and Investigations Office considered 2,154 complaints, of which I think 55 were upheld. And what happened to those judges against whom complaints were upheld? Well, a third were dismissed, suspended, a third retired, and a third were reprimanded. You might wonder how many judges there are, and I wish I could tell you precisely, but my researchers didn't provide a figure. There are several thousand, because this includes judges of the civil, family, and criminal courts, judges of the various tribunals that deal with matters such as benefits, immigration, mental health. So there are several thousands of judges. What sort of conduct by a judge can justify his removal from office? Judges can be removed from office on grounds which relate to their conduct as judges or their personal lives. And this can include misbehaviour, such as a criminal conviction, including a conviction for driving under the influence of alcohol. That is absolutely an offence for which you will be dismissed from office, and every judge knows it. You could be dismissed from illness if you're simply unable to perform your duties for a length of time, if you fail to comply with the training requirements, or if you fail over a period of time to observe the standards that I've talked about, the standards of behaviour that are expected of a holder of judicial office. And again, any such decision will be taken jointly by the Lord Chancellor and the Lord Chief Justice. This independence from the executive is particularly important because there is an area of law where judges review the conduct of government. The rule of law requires that courts should have jurisdiction to scrutinize the actions of government to ensure that they are lawful and to prevent arbitrary and unfair decisions. In England, the legal process whereby the legality of government action is reviewed by the courts is called judicial review. It's an area of law which has grown enormously in the last 30 years. Various reasons have been put forward for this, but two that have been suggested are that modern society is increasingly complex, and that brings with it an increasing amount of executive control over the activities of the citizen. And another is that there is a growing recognition amongst citizens that it is possible to challenge executive action. This work can bring the judges into apparent conflict with the executive, and judges can be, and often are, in this area of work, accused of overstepping their role. And on occasions, politicians call for a reduction in the powers of judges. But the judges who do this work, and it's done at the High Court level, do not substitute their decisions for those of the executives. They check whether the executive has acted in accordance with the law as laid down by Parliament. And so you can see that in order for judges to do this work and all the other work, they need to be protective from executive power and influence. It's interesting to note that the government often asks senior judges to conduct public inquiries, commissions or committees, and to hold inquests. This can happen if there's an important matter of public interest. To give you a few examples, there have been a number of inquiries into British conduct towards Iraq. There's a report outstanding now, due to be published shortly. There is an inquest being conducted by a judge into the deaths of nearly 100 people who died as a result of something which happened at a football stadium 25 years ago. That was a matter it was thought was closed, but has been reopened, and a new inquest is being conducted by a senior judge. And in the last 2 years, there was an inquiry into newspapers hacking into individuals' private telephones, computers. The terms of reference for public inquiries which are outside the legal system, they are extrajudicial inquiries, are set by the government after negotiation with the judge who is going to conduct the inquiry and in response to public opinion. Whether or not the government implements the judge's recommendations is, of course, a matter for the government. But there have been increasing numbers of these judge-led inquiries in recent years, which, if nothing else, suggests that there is confidence in the ability of judges to act independently. I want to say a little about immunity. Judges must be able to administer justice under the protection of the law and without fear of reprisals. This safeguard is in the professional and personal interest of judges, of course, but it also benefits the public, who know that judges exercise their official functions independently and without being afraid of the consequences. And therefore, judges are immune from criminal prosecution for any acts they carry out in the performance of their judicial function. And they can't be sued in the civil courts for damages for things they say about parties or witnesses in cases in front of them. But that doesn't mean that judges are above the law. We are subject to the law in the same way as any other citizen in respect of the way in which we conduct our private lives. A person who is dissatisfied with the decision of a judge in a case can appeal to the court at the next highest level. In the case of circuit judges, appeals go to the Court of Appeal. But that person cannot appeal just because he doesn't like the judge's decision or doesn't agree with it. He has to have grounds, reasons, such as that the circuit judge made a mistake of law or mistake of fact, or that there's some compelling reason why an appeal should be heard, which usually refers to matters of public policy and are much more uncommon. The Court of Appeal sometimes criticises the judge from whom the appeal has gone to them, and if the criticism is serious, then that can be sent to the senior judge of the circuit, the group in which the judge works. A judge may be given advice or training, or if it's very serious, then again the Lord Chancellor and the Lord Chief Justice will look at the matter. Independence from other judges. I said that each judge does what he or she thinks is right independently from all the other judges. And English judges have a great deal of freedom to exercise their own judgment and do what they think is right in the circumstances of each individual case. But if judges are independent and each judge can decide a dispute or deliver a criminal sentence as he thinks right, there is a risk that there may be inconsistency between their decisions, which would be unfair. One judge may believe in punishing criminals and send them to prison for long periods of time. Another may believe in rehabilitation and think that non-custodial sentences or short sentences are more effective. The offender would, of course, prefer to come in front of the second judge, but he can't choose his judge. So how does the English legal system guard against such apparent unfairness? The English legal system has developed over hundreds of years. You may know it's not a codified system. It's made up of laws, regulations, and the decisions of senior judges deciding cases in the higher courts, in particular the Court of Appeal and the Supreme Court. A statement of law made by a senior judge, for example, to clarify the law, can become binding on judges in the lower courts. This means that a judge of a lower court who has to consider a rather similar case must consider the decision of the higher court and has to apply the law as stated by the senior judge. This system is called the system of precedent, and it contributes to the development of the law and also creates a degree of consistency and greater certainty about how the law will be applied. It could be seen as limiting the freedom of the judge of the lower court, but that freedom is limited by the law. In the Crown Court criminal trial, the judge doesn't decide whether somebody is innocent or guilty, except in very, very rare circumstances. That decision is made by the jury, and the jury is made up of resident citizens who are registered voters, and they are selected at random. If the jury finds the defendant guilty, then the judge has to decide the sentence, taking into account any sentencing provisions in the law and also the guidelines published by the Sentencing Council. This Sentencing Council was set up to promote greater transparency and consistency in sentencing while maintaining the independence of the judiciary. It is an independent body. Some of the members are judges, others are members of the public, and they are appointed after open competition. The primary role of the Sentencing Council is to issue guidelines on sentencing which the courts must follow unless the judge decides that it is in the interests of justice not to follow the guidelines. That definition of the Sentencing Council's primary function expresses the balance between the judge's independence and the need for consistency. A judge passing a criminal sentence must follow the appropriate guideline unless that judge decides that it's in the interests of justice not to do so. That leaves the judge considerable freedom, although he must be prepared to justify his reasons for taking a different view from the guidelines when he announces his sentence. I want to say a little about the appearance of independence and the conflict of interest. It should be obvious that a judge cannot decide a case in which he has a personal interest, cannot decide a case in where he will benefit from a particular result or where his family or friends may benefit or are involved. I've said that judges must not only be independent, they must be seen to be independent. So it's also accepted that a judge should not decide a case if there is a degree of connection between the judge and one of the parties, so that he would appear to be deciding a case in which he has a personal interest. And there's an example which is usually cited to explain this. It's quite an old example now, it's from 1999. But in England, in London in 1999, a Spanish magistrate applied for an extradition order for the former president of Chile, General Pinochet. The case went all the way up to the House of Lords, which was then our highest court. Now it's the Supreme Court. One of the members of the court was Lord Hoffman, a judge with the highest reputation. But Lord Hoffman was also a member of Amnesty International. You may know of it. It's an organization which campaigns for the rights of political prisoners and detainees. And it was a party to the proceedings. And when the House of Lords became aware of this, the appeal was heard again by a different panel from the House of Lords, which did not include Lord Hoffman. Independence from the legislature. Members of Parliament are expected to observe the rule that they do not discuss matters which are before the courts, which we call, using the Latin, sub judice. That limits the freedoms of the members of Parliament, but it protects the court proceedings from interference and prejudice. There is a convention or tradition that members of Parliament and members of the government do not criticise individual judges or judges in general for their decision unless there is a motion tabled for discussion before the House of Commons, for example, criticising judges in general for their conduct of criminal trials or their sentences. Sentencing is the recurring area of interest and criticism. This enables politicians to comment, but in a limited way, when they consider that judges are acting with insensitivity to changes in social opinion. Of course, a government can always bring in legislation which would prevent a judge from making a similar decision in the future by changing the law. I've said that there is a strong convention that judges do not get involved in politics and cannot stand for Parliament. What about independence from the media and from public opinion, as often expressed through the internet? Should a judge be independent from what the public think ought to be happening? Or should we take account of popular views as expressed by some of the press? The press has for a long time complained that family cases are conducted in secret by judges behind closed doors so that nobody knows what is happening. My view is that proceedings are conducted confidentially, and that is usually to protect the interests of the children. But it's acknowledged, and has been acknowledged by recent changes, that there has to be more openness, more transparency. And so, in an attempt to reassure the public, about 5 years ago, it was agreed that properly accredited members of the press could come into the family courts, although after a little excitement, I have to say, on the whole, they don't seem to be very interested. And early this year, new laws were introduced, or new regulations, which provide that judgments will be published on a particular website, but they will be published in anonymized form so that it won't be possible to identify the children or the families, because again, the confidentiality of the children needs to be protected. For many years, as I've said, in the UK, there has been a lively debate about the sentencing of offenders. I can summarize the sort of criticism in this way: these judges are out of touch, they don't know what they're doing, usually because the writer thinks the sentence should have been a great deal longer. The government has responded in two ways. The first is that in respect of some offences which raise a great deal of concern, the maximum sentences have been increased. So, for example, for serious sexual offences, for causing death by dangerous driving. But increasing the range within which a sentence can be passed doesn't necessarily mean that the judge will pass a sentence at the top of the range, because the judge will do what he or she thinks is right. And so in recent years, the government has introduced a number of mandatory minimum sentences. For example, a life sentence for a second serious assault, whenever it was committed, and a mandatory minimum of 5 years imprisonment for possession of firearms. The current debate in the press is about knife crime, particularly amongst young people, often very young people. Although the official statistics tell us that crime, including knife crime, is at the lowest that it has been for many years, the popular perception is that knife crime is a real and present and increasing threat. And there is a lot of pressure in the popular press for judges to pass immediate sentences of imprisonment on everybody who carries a knife, no matter what their age, no matter what the circumstances. That is a debate which continues. I wanted to say just a little bit, finally, about European law. Because apart from criminal law, the other area in which judges are often criticized is with regard to human rights, and in particular the effect of the Human Rights Act. Britain was a signatory to the European Convention on Human Rights in 1956, and that was incorporated into English law in 1998. That act makes the whole of English law subject to a process of comparison with the standards set out in the Convention, which sets out various basic principles, for example, the right to a fair trial, and of importance to a family judge, the right to a family life. There are critics who consider that the Human Rights Act has given Europe the final say over English law. But that ignores the fact that the UK had signed the Convention a long time ago, and therefore many of the provisions of the Convention had already formed part of English law even before the Act was passed. Sometimes it's suggested that judges are able to overrule English law by exercising powers granted in Europe. For example, by saying that English law is incompatible with rights and freedoms guaranteed by the European Convention on Human Rights. But a declaration of incompatibility does not change English law. That has to be done by Parliament. If it's done at all, they have to amend English law to make it compatible. So the ultimate decision remains with Parliament, not with the judges. Occasionally, the press approves of a decision of the judges vis-à-vis Europe. So in July last year, the European Court of Human Rights in Strasbourg ruled that whole life sentences, which had been passed on 3 murderers, amounted to inhumane and degrading treatment because they said there was no formal review mechanism that would give them the prospect of release. Now, you may or may not think that people should have a right to a prospect of release, but in February 2014, the Court of Appeal decided that the European Court judges were wrong because there is a power to review these whole life sentences, but in very exceptional circumstances. So I come back to my original question: am I acting independently when I decide the cases in my court? The independence of the judiciary in the UK is asserted, protected, and highly valued. And judges tend to be the kind of people who have their own views and know their own minds. They prize their independence and they protect it fiercely. whenever the government announces plans to change the laws in ways which judges think might restrict their independence, there is a huge outcry, and not just from judges, from all of those who understand the value to the whole of society of judicial independence. The laws and the regulations and the traditions which support judicial independence are balanced against the rights of people to a reasonable level of consistency between different levels of courts and between judges. This balancing of interests is characteristic of other aspects of democracy, as you will know very well. So I consider that when I sit as a judge, I make my own decisions independently, but it is right and proper that I should be accountable for them. Spasiba za vнимание.
Коллеги, у нас чуть более получаса на дискуссию и ваши вопросы. Откроет...
Colleagues, we have about half an hour for questions and answers. Thank you very much. I'm Stanislav Stanskich, alumnus of the School of 2012. I hope you can hear me. Yeah. Stanislav Stanskich, while I'm a lawyer, but my question would be less on judicial matters. Can you hear me now? Could you hear me now? Can you hear me now?
Just a little louder, please.
All right. Yep. Thank you. Yep. This might be 3. Yeah. Can you hear me now? Hello? Hello? Channel 5. Am I on Channel 5? Lovely. Thank you. Thank you very much. Thank you very much indeed. I'm a lawyer, but my question would be less on judicial matters. Do you watch either American or British court series on TV? There's one series in Russia which about the English about the barristers. It's called Silk, yeah, and it's very popular in Russia. Do you watch any of these yourself? One of the most the Boston Legal is one of the most popular U.S. series. Could you comment on any of these?
Yes, I do watch a lot
Of them. And I also watch Scandi thrillers. I don't know if Scandi thrillers have reached Russia. Scandinavian thrillers. I watch all of that. I used to think, and I'm sure this is true of all of us who see either on television or in the press a report about something we know about, and you read the report and you think, that's wrong, or that's only part of the story. And I used to think that they were terrible, and so I would find myself shouting at the television. That's wrong. It's not like that. But Silk is very, very good. It's very well written. They're good stories. Of course, they're quite exciting stories. I'm sure most lawyers would say their lives are not as exciting as that. But I think the courtroom scenes are very well done. It's quite realistic, and it's very highly regarded amongst lawyers, as well as being very popular in England as well.
Так, Надарья Дороселия.
A graduate from Georgia. Thank you. Nadarya, graduate 2013. It was really a pleasure. It was really a pleasure to hear and listen. Thank you, Madam, for this excellent presentation. I wanted to dwell upon Just fine point. I'm from Georgia, and for us this is really very important in a sense that the rule of law is, where does the rule of law stop and where does the rule of, again it's untranslatable, rule of law and rule of right, if you allow me to translate it this way, because there's people who took part or rather executed according to the criminal laws that were in effect at that time, using incorrect rules of, and then new government came into place and the same judges now do the same under the new government, and it is very hard right now to achieve something to make these judges to more or less be requalified or should stay away from exercising their job as a judge. For us, the most sensitive issue is for us to get some explanation in greater detail about the rule of law, because laws are adopted everywhere and they're supposed to be working everywhere. But what we had in our legal practice and what we saw in other countries where democracy is not that developed, this is really very important. I apologize for being, maybe I didn't get my message across about this. Thank you, thank you.
Well, I'm sure you understand that I can't comment on the particular situation in Georgia. I would make just some general observations. When you ask where the rule of law begins and rights stop, they're really all part of the same system. The object of a society which acts under the rule of law is to assure rights, the individuals and collective rights. So it's really not a question of where one stops and the other starts, but seeing them as all part of the same system. How anybody creates a judiciary that is independent is a difficult question, because it seems to me that it is something, it's about culture, it's about the culture of the society. It's not just the judges who have to think they should be independent. Everybody else has to think that judges should be independent. The government, the parliament, society as a whole. And what I've been trying to describe are all the various ways, some of which are set out in law, others are about little matters, things that may not seem so important, like how judges are appointed, but are essential, are crucial to ensuring independence, because the thinking about independence has to go all the way through the system, from the bottom to the top, in every aspect of it. There have been lots of programs over the years, certainly with Russia, with various other countries, exchanges, judges coming here, judges coming to London. We can all do our best to talk to one another and explain how we all do things. We can all learn from one another, but I think it's difficult for me to say how you can, in any society, ensure that judges are independent, because I think it's much more complicated than simply making sure that the judges know what they're supposed to do. They have to be protected and supported by society as a whole.
Коллега, вам слово.
Dear colleague, this is your say now. Nikita Molchakov from Moscow speaks English.
Great description of the judicial system of English that dwells, but my question won't be about the judges, it will be about the judiciary branch of power. We know that in 2005 a revolutionary innovation in the history of the judicial system of Great Britain took place. This reform and the creation of the Supreme Court and the privation of the House of Lords of its right to judge. Could you please speak about the results of these reforms? Nearly 10 years passed, and how this reform influenced the English legal system, and what are the perspectives of it? It's very interesting for us, for Russians, because we are going to have a judicial reform, now. And what is the British experience? Thank you.
Well, the main object of the Constitutional Reform Act of 2005 was, as you said, to create the Supreme Court. Before that, the highest court in the UK was the House of Lords, but the House of Lords is, of course, also the second house, the upper house of Parliament. And therefore, there was at least an appearance of some confusion between the separation of Parliament and the judiciary. In fact, the lords who were judges, who were referred to as law lords, were judges and generally didn't take part in politics, and certainly the members of the House of Lords who were not judges did not take part in any court proceedings. So there was a de facto separation. But there had long been thinking that there should be a totally separate Supreme Court, more along the lines of European models. And there was a great deal of support for this and for the separation of the role of the Lord Chancellor, who, as I've said now, is clearly a member of the executive, separating out the role of being head of judiciary to the Lord Chief Justice. How do I think the reforms are working? Well, I think they've certainly been accepted. And it's very interesting to see the way the Supreme Court works. It's quite easy to go and observe the proceedings of the Supreme Court. The proceedings are also filmed. They have made films so that people have been more aware of what goes on, whereas before, what happened in the House of Lords was really rather more, hidden is not the right word, but just people didn't know about it very much. So in the course of creating the Supreme Court, there was a real effort to make it transparent and open to the public so that people understood how it works. I think the reforms have been accepted and have been very successful. For us, they were major reforms because those sorts of institutional changes, they take place rarely and very slowly.
Сударыня, вам слово, прошу.
Madam, you now have the floor. Maria Guleva from St. Petersburg speaks English.
A question which is probably quite obvious, but for us in Russia it's not really. You said that in Britain, judges become, they sort of lose income if they change from private practice to the, So what's the incentive? What motivation drives a person into becoming a judge if it's not financial profit?
It's a fantastic job. I think certainly very senior judges and those who are appointed to the High Court and upwards will often have been earning or capable of earning a great deal more. I have to say we're not badly paid, so it's not that we do it for no money at all. But the incentive is that it is a wonderful job. So if you think that this is an important part of the administration of justice, and if you like making decisions, it's a very different function from being an advocate. An advocate is arguing a case, one case. The judge has to listen to all the cases and form a view and manage the process of the case in front of him or her, form a judgment, and then give that judgment in a way that, in particular, the person who loses understands why he lost. It's a very different role. It's not for everybody. There are certainly plenty of highly paid and not so highly paid lawyers who don't want to do this. But I think there are certainly judges. I always wanted to be a judge. I just always wanted to be a judge. So it's difficult to explain, but I always thought it was an interesting job and I wanted the responsibility and to make those sorts of decisions. And because I was a solicitor, and in those days it was unusual for a solicitor to become a judge, it was possible, but it was not regarded as usual. I thought that somebody who had the sort of very varied background I have should contribute. There should be some judges like me on the judiciary.
Так, Станимир Кайтаски.
Stanimir, please, actually a lawyer from Bulgaria. Yes, thank you very much for introducing me. But I have a question. What is the attitude, how do you ensure independence of the court? And how do you affiliation with the secret societies, for example, Mason logias? If so, how does it correlate? And if it is the case, then why do they have to declare their membership if they say belong to some secret society? And the second question, what cases do you hear? Is it civil law or is it criminal cases?
Masons. I think a long time ago, when I was a part-time judge, before I became a full-time judge, I had to fill in a form saying whether I was a Mason. I don't even know if there are any women who are Masons. I don't know if you can be a Mason if you're a woman, but anyway, I'm not. I don't know the answer to your question, because if somebody is standing in front of me in court, I don't know if he's a Mason. I'm not told. I don't ask. It's of absolutely no interest to me. It has no effect whatsoever on any decision I make or any other judge that I know of makes. So I'm not sure really why why it's considered so important. And I don't know of any other secret societies, so we as judges don't have relationships with them. I don't think I can say anything more about that. The sort of work I do, mostly I deal with cases that involve abused children who've been abused, usually by their families, physically, emotionally, sexually, where the state considers that the children should be removed from the parents' care. I think you have a similar concept, Lichenia. And I deal with other family cases. I also deal with civil cases, which could be a company suing another company under a contract, that sort of civil work. And finally, I do criminal work. So I do a bit of everything, because I was always what we call a general practitioner, and I like variety. But a lot of judges now specialize in maybe one area.
Вопрос нашего слушателя из Армении, пожалуйста.
A question from a student from Armenia. Speaks English.
School of Political Studies. I think we'll all agree that the independent judiciary would not be created anywhere overnight, but especially it is true for the newly independent states of post-Soviet countries. In this regard, I would like to ask, where do you see the weakest link towards building that integrity in judiciary? Is it the political will, maybe? Because it seems like the civil society wants it, and the parliaments, the executive branch of power, wants to do the right things, passing the laws. But it takes political will, to me, to severely punish the ones that are not integrated to the judiciary, and promote the ones that are building integrity in judiciary.
Well, again, I can't comment on what may or may not be happening in Russia today. But I think the difficulty with judicial independence is, as you can see, everybody's involved. Everybody has to be involved. The judges, the politicians, the government, every man and woman who might one day have a case in front of the courts. Everybody has to be involved, and everybody has to buy in to the culture. Does it require an act of political will? Well, I'm sure it does. It requires acts of all sorts of will. As to the suggestion that it requires political will to discipline judges who do not act independently and promote those who do, in our system, disciplinary proceedings are taken, decisions are taken by the two people I mentioned, one of whom is a member of the government and the other one is the head of the judiciary. So you don't have just a political decision about individual disciplinary proceedings. It's a decision taken between the executive and the judiciary. And as to the promotion of judges who do well, I don't think any of us is promoted because we're independent, because it's expected. It's not something for which you should receive a promotion, though I can imagine it might have a role to play where you're trying to establish a system. The difficulty is it does take a long time. I told you that it was first mentioned in English law 300 years ago, so I'm not claiming that we did this overnight. It took a long time, and I'm sure it does in all societies.
Юрий, прошу.
Yuri, you now have the floor, please. Yuri Labunov from Bryansk. I would like to ask a question about two notions, the letter of the law and the spirit of the law. For example, in Bryansk we had a court hearing when the administration they tried to punish it and tried to build a road. The road was really in a hazardous condition. The city administration, like municipals, showed a paper to the like expert assessment to the court, which said that the road is okay, that it has been repaired. The point of fact, he could not. And the court took a decision and followed this paper. The letters sort of seemed to be observed, but the spirit certainly was not, because the road was absolutely unfit for riding. For the judges in Britain, what matters most? Is it the spirit or the letter of the law? Literally speaking.
Difference. There shouldn't be a difference. That sort of case in England would probably come under planning or administrative law, and the decision would be made on the basis of the evidence, not on an assertion in a letter by one side, but on examination of all the evidence. And that's what you do as a judge. You look at the evidence, you decide what the facts are, you apply the law to the facts. So there shouldn't really be a difference between the spirit of the law and what the law actually says. Sometimes, however, what the law actually says is not very clear. And it's in cases like those that eventually there will be a decision of a senior court, because the case will go on appeal to the Court of Appeal or the Supreme Court, and they will make a decision which will clarify unclear law, and that will become precedent binding on judges of the lower courts. But I think the answer to your question is, which is more important? They're both important, and they shouldn't be at odds. They shouldn't be in conflict.
Коллеги, я надеюсь, что госпожа...
Dear colleagues, I hope that Madam Judge will forgive me for sharing you the story about the letter and the spirit of the law, to just sort of somehow just to make you... What justifies me is that this story really is about UK. Some 10 years ago, this school ran a seminar with the support of our British friends, and according to the agenda, we were supposed to visit one of the buildings of the House of Parliaments. Not the one which is now has Big Ben, but the one next door to it. There's a set of buildings. As they did security check, as we tried to enter the building, one of our students, they found maybe a knife, a portable knife, you know, a small knife, just a pen knife that he carried with him. And this really became interested heavily. The interests were on duty, and they sort of wanted to have a talk with him. They asked him, why is it that you carry a knife with you? It's not that it's not customary. It's forbidden to actually carry these portable knives this length. Is it that everybody carries a knife in Russia? Actually, they pointed out to that gentleman that he obviously is at odds with the letter of the law, with the legal language, and we thought that he would be punished at the very least by barring him a visa, by denying him a visa further on. Why do they need to allow a person who carries this gun around about London, let alone wants to enter the House of Parliament, carries it on him? No, no way, no way. They just took everything into account. There was just like a sort of hearing on site, and they decided, okay, it's a different culture so far. This is the case. This is the way they are right now. So...
I'm delighted.
But it is illegal to carry a knife, any kind of knife, in England, unless you have reasonable excuse, which might mean, for example, that you genuinely need it for your work. So you might be a chef. If you're a chef going to work, you might have a knife with you. When I was a solicitor in practice, the excuse that clients usually gave me for while they were carrying a knife was that they used it to peel fruit, which just told me that certain parts of London were full of terribly polite people who only peeled their fruit with a knife. It is illegal, and as I say, there has been enormous amount, or there is a perception that there's been an enormous amount of knife crime. There are some dreadful figures, and I don't remember them precisely, but murders of young people, young men, in gang fights with knives, there are really a lot of them, and they are dreadful and tragic. But clearly, not just... I think that the officers, the security officers, are not just saying to your colleague, well, you come from a different culture, no doubt you all carry knives in Russia, so that's okay. He was saying that you've got a reasonable excuse. You didn't know that you're not allowed to carry a knife here. And I expect he was probably had to leave the knife with the security officers and pick it up when he came out. I must say, when I used to travel from Moscow to London when I was living here with my son, then age 5, we had to hand in his plastic toy gun, this big, at the beginning when we got to the airport, and we received it when we got to London. So.
В данном случае смягчающим обстоятельством послужило наличие российского паспорта.
Anyway, this very fact that he, mitigating a second consideration was that he carried a Russian passport. Okay, colleague, sitting somewhere in the middle. Good day. Albert Kalimov from Yamal-Nenetsk Autonomous District. In our judicial system, suffers, well, in any state, it suffers from reason that the judicial system not always is adequate to those people who are appointed. What I mean, maybe it is a provocative question in a way, but what if you look at the cases, say, that pertain to the Queen or to the members of the royal family? She's the one who appoints the judges. How would you consider this case then? In Russia, those who appoint, if they are under investigation and under court hearing, you can understand what verdict would be returned.
I'm not sure I've understood. Are you asking me whether a judge could be independent if there was a case against Prince William? Yes? Oh, I see. I've never ever heard of any such thing happening. They are pretty well protected. I don't know what happens to if they're speeding. They're probably not speeding because they're